Hi, I'm Jenni McKenna. I'm the owner-broker of McKenna Property Management. I got my real estate license in 1993, sold real estate until 2005, which is when I opened up McKenna Property Management. So I have over 20 years of property management experience added on top of the real estate experience here in the Las Vegas Valley. Today, I am going to read Reddit questions, and I'm going to give my opinion to help anyone out there that might be in this same situation. Question number 1. I've been a landlord for 4 rental units for around 8 years now. I keep my rent cheap, well below market value because I feel bad. No matter how well I do my job, repair things in a timely manner, keep rent low, cutting down on my own profits, there is always animosity. Doesn't matter how polite I am, tenants through the years always have an issue and give me an attitude. They absolutely hate handing me their money every month. Any advice dealing with selling your property while tenants are still there? Okay, well, first of all, I completely relate to you as far as you give to a resident/tenant. And for some reason, they feel like they're entitled to say mean things to you, call you out on NRS laws, not be very nice people overall. I realize that. I think you keeping the rent below market actually does not always do what you want it to do. A little bit below market is great. As far as the advice from the realtor saying that your property is more valuable with tenants in it, if it is a fourplex or something along the lines where you're really only appealing to an investor, that might be okay, but that is the exception. The rule is get the resident or the tenant out of the property, have the property be vacant, and then that way you can show the property in its best light. Residents and tenants do not show properties when they're living in them. So if you're not getting your property shown, you are not going to get offers. And if they're going to make it difficult to get the property shown and they're going to show it with attitude, or they're going to profess all the problems that they have had with that particular property, obviously that is going to hurt the sale. If you're serious about selling, get rid of the residents and then fix it up, make it fresh, make it clean. You don't have to do a full rehab. Make it fresh, make it clean, and then price it right. That is my advice to question number 1, where he identified himself as, I don't think I'm cut out for this. Property management, you have to have thick skin. So I can relate, but it is something that if you look at the long picture, the big picture, you're making legacy money and it's worth it. The other option is if you're sick and tired of having to deal with the residents, hire a property manager, and a good property manager will take all those headaches away from you. Am I responsible for rent if ex-fiance kicked me out? For context, I found out she was cheating on me, and when I confronted her, I came home to my stuff thrown out of the house after I got off work, and the locks were changed. She is refusing entry to me, yet we're both on the lease. My name is on the water bill too. Am I legally required to keep paying rent? We have a private landlord and we just renewed our lease in July. I want to talk to our landlord, but the only thing stopping me is I don't want to have to pay all these fees for early termination. Okay, this is tricky. Your lease is a contract. So you and your ex-fiance, you guys are contractually responsible together. If you can speak with the landlord and explain your circumstance and say that I'm just not living in the property because of the circumstances, I would like to be taken off of the lease, you're probably only going to be paying like an admin fee, as long as your ex-fiance is okay to take on the full responsibility of the lease. And don't forget, the landlord has to be willing to allow an individual the sole responsibility of the lease. You may have only gotten the lease approved when you applied because it was double income. Maybe, the credit situation. I don't know all the background on that. So if you get taken off the lease, will your ex-fiance still be able to afford the lease terms? The landlord is going to want to make sure that they're comfortable with that. Also remember that when you want to be taken off of the lease, there needs to be paperwork done, a minimum, an addendum. What would be great is if they just did a brand new lease with your ex-fiance's name. carrying it out to whatever your lease terminated, whether it be the next 7 months, 8 months, whatever. So mirror your original lease, but just get your name taken off. Don't forget your security deposit. If you put up half of that security deposit and that's rightfully yours, you may want to ask that from your ex-fiance. Personally, it would be better if you did it between each of you so that the landlord doesn't have to deal with it. That's usually when the landlord's like, oh, that's too much headache. I'm just going to keep these two on this contract. Because remember, you are obligated. If she falls behind on making the lease payment, it will ding your credit. So you want to make sure that you're current on the lease. But even though you're not living there, you are the contractual person that is obligated between you and your ex. And if you and your ex were splitting the rent and your ex now doesn't want to pay her portion, it's going to affect you. So just be very cautious. Make sure you keep your credit good. But the very first thing you want to do is you want to call the landlord. You're not asking for an early out. You're asking for yourself to be removed from the lease. If you and your fiance have to do an early out, maybe propose a 1-month buyout, where you pay your month's rent on the month that you're not there. Landlords pretty much like that. And that might be one way that you can get out of the lease completely and then still not have anything negative on your credit, because you do not want a landlord collection. You do not want monies to be attached to your credit. So be very cautious. Make sure your credit stays good. And my rule of thumb is just be honest with your landlord. Don't make it drama. Just be very upfront, very forward on what happened and why you don't feel comfortable living there, and that, you're dissolving the relationship and you would like to be taken off of that lease agreement. Owning rentals with my wife is testing our teamwork more than our marriage ever did. I can believe that, especially since I work for my dad. My husband works in the real estate section of our company, and 2 of my 3 children work in the property management section of my company. So I can relate to the challenges that happen with that. Me and my wife bought a few rental properties together a couple of years ago, and lately it's been causing more tension than either of us expected. We both work hard and earn well, but when it comes to the rentals, deciding who handles what, how to split expenses, or who deals with tenants, we just can't seem to stay on the same page. It's not about the money itself, it's about control and communication. She feels I'm too strict with budgets, and I think she's too lenient with repairs and tenant requests. Sometimes I wonder if couples should treat co-owning property like a business partnership with clear written agreements from the start, because emotions really get in the way. Has anyone else has trouble separating us as a couple from us as co-owners? How do you make it work without it turning into constant small fights? I'm not self-promoting. I'm really not. But your solution is to hire a property management company. Because once you hire the property management company, they take all of that little bickering and deciding off the table. Let the property management company tell the tenant no. You don't have to make that decision. The property management company will email you and say, this is what the resident tenant asked. We said no, move on. Or the property management company could email and say, this is what the resident tenant asked. We don't believe that this is for habitability reasons, so we advise you to say no. They know the law, so let the property management company handle the problems. Make sure they are truly a reliable property management company, and your problems honestly will be resolved. You don't have to create a contract for co-ownership. You don't have to do any of that kind of business stuff, because the property management company does it for you. Let them do their job. They will appreciate you for letting them do their job. You don't have to micromanage them. And then you and your spouse will be happy, happy, happy. And I say the same thing, whether it be with a father and a son, or whether it be just 2 really good friends. Why stress the friendship? Hire a professional, take it out of whatever whatever the rent comes in, they'll charge you the management fee, but it is well worth it. Property management company completely mismanaging my condo. Any recommendations? I own a modest condo, and the property management company that manages it has made serious breaches of contract. I don't know if it'd be worth filing a suit, but they've cost me so much money and created a huge burden of stress. If I change companies, won't I lose all the fees I paid? There is a lot to uncover in this question. First, I want to apologize. I am sorry that you have gotten into a contract situation with what it sounds like a property management company that is not upfront. Sounds like they're not good at communication, and for whatever reason has done things that obviously were not within the realm of your property management agreement. So with that being said, I want to dissect in and go with that issue where they charged you thousands in repairs and maintenance without getting you approval. And your threshold was at 500. The first thing that pops in my head is, was that a habitability issue? Because thousands of dollars from a property management company, we do not like to spend that without approval. It just scares us. I mean, even companies that have bad communication skills, and bad accounting, you do not want to be on the hook with the vendor for a lot of money without getting that approval from the owner. It's very unfortunate that they did not communicate with you before, obviously they'd had to do the repair, but then they should have immediately communicated what was going on. But I'm going to assume that that's probably what happened there. And yeah, communication skill would have been helpful on that. When it came to the unit storage closet, that they should have checked. Yeah, not to say that property management companies don't make mistakes, but when they found out that they rented the unit and the closet was still full of the previous resident's belongings, they should have jumped on it immediately. And if that was something that we had done, we would have just absorbed the cost of getting all that stuff hauled off. So yeah, they should have caught that. That is something that should have definitely been in the rent-ready process. And if the field agent didn't catch it, then the listing agent should have caught it. So a couple of things that got overlooked there. With the tenant who just broke the lease, okay, you're not gonna like what I have to say on this. Nevada, I like to say, is the wild, wild west when it comes to owning rental property. I love their eviction laws because if a resident doesn't pay rent by the 5th of the month, you can serve them the 7-day pay or quit. And then within those 7 working days, if they still haven't paid the rent, you can serve them the start of the 24-hour. They can appeal it. You might have to go to court. But basically, to sum it up, you can get a non-paying resident out of a property in about 45 to 50 days. Our state is so good with that. But flip the coin. The other side of it is the judges do not really rule in favor of landlords or owners that want to grab all of that rent from the resident who maybe breached their lease. In my world, if a tenant or resident breaches a lease, we are going to automatically forfeit the security deposit because they breached the lease. So that's part of our contract. And then we are going to charge at least 1 month's rent towards their security deposit transmittal, as well as anything else that we needed to clean up that would have been considered over normal wear and tear. I'm not sure how your management company handled the breach of lease, but that's how we would handle it because damages had been occurred to you as the owner. However, I don't want to keep the property off the market just to prove a point and then go to court to try and get a judgment against your previous tenant or resident. It doesn't make sense. The money's not being spent logically that way. Better to get the property on the market as quickly as you can, get a new resident in there, and then start collecting the money off of the rent. But to what your question said, they also didn't catch the pet damage. That also is not fortunate. I mean, because pet damage with urine, I'm assuming, maybe the doors got scratched. You want to catch those at the move out because you definitely want to attach that to the security deposit transmittal. I will tell you a couple of things that have happened to us. We have walked properties when it's nice and sunny and there's no humidity and we don't smell any pet urine. We do carpet clean and we get everything cleaned up, ready for the next resident, and then it rains. and all of a sudden the humidity is in the air and the smells that we didn't smell when we originally walked the property, all of a sudden now the property smells. And that has happened. That's happened when we have moved somebody into a property and everything has been fine. And then the first rainstorm, all these pet smells come into play. If that happens and when that happens with us, we do just as a company pay for a new carpet cleaning. And with the new carpet cleaning and the fact that we don't get a lot of rain here in Nevada, it usually satisfies the new resident and then we move on. Yeah, that could be touchy because it might have not smelt like the pet if you're just talking about urine on the carpet. Obviously, if the pet had scratched the door, that should have been seen and taken care of. And then as the management company is pressuring you to lower the rent, don't shoot the messenger. Our rents are really soft right now. I am filming this at the end of 2025, and I weekly have conversations with my owners that have vacant properties on the market. When I analyze fair market rent, I take all the data. I give my owners the most accurate rental asking price I possibly can. I want them to get as much as that the market bears, but I also understand that if I go too high, it's going to sit for too long. So we will start at a certain amount that I think is right. But if within 10 days, we don't have enough showings or we don't have any applications, my conversation with the owner is, let's lower the rent 9 out of 10 times. Now, if I get feedback from a showing agent or from somebody who saw the property and it's something we can fix, maybe there's teal green in the kitchen and the last 2 showings said, no, I'm not going to rent this because I don't like that color. Then maybe if we neutralize it, we don't have to adjust the rent. We just have to pay for the repainting of the kitchen. But 9 out of 10 times, it is the asking rent. There is a sweet spot and you've got to find it. And sometimes you have to put something out on the market in order to determine what the sweet spot is. So I know that you feel like the management company is pressuring you to lower the rent, but it may just be that you are too high for what the market is today. And then to answer your question on, can you move management companies? Yeah, you can, especially with what kind of case you have right here. So the way to do that is to, 1, find a property management company that you feel good with, interview them, do your due diligence, and if you really like them, then you want to go to the broker of the property management company that you are with, and you want to explain your grievances, and you want to be very transparent about it, and you want to go, look, I don't want to take you to court. I don't want to sue you, though I have lost thousands of dollars in my mind. What I really want from you is just release me from the contract. And no broker wants to be sued. No broker wants to be brought before the Nevada Real Estate Division. By just being very upfront, very forward, and giving them an out, then they're going to release you more than likely from your contract. So that's what I would do, and I would especially try and do that before you get a tenant in the property. So if you're on the market right now for rent, this would be your perfect time to do a switch over to another management company. So hopefully that answered your question pertaining to your property management company that has not done well for you. Is attitude the root of everything? I screen my tenants pretty carefully: credit, background, income, rental history, references, the whole checklist. But I keep running into this thought. No matter how solid someone looks on paper, if their attitude is bad, it almost always turns into problems. I have had folks with less than great credit who turned out to be awesome tenants, respectful, easy to communicate with, and handled issues responsibly. And I've had people with perfect applications who ended up being combative, entitled, or just a headache to deal with. So now I'm wondering, do you think attitude matters more than the actual screening metrics? Or is it just luck of the draw sometimes? I'm right there with you. I'm right there with you. I have seen perfect applications, and when we put them into one of our rentals, they are miserable to work with. We call them high maintenance residents. They call on everything. They demand everything. They act like everything they do is perfect and everything we're doing is not what it should be done like. I've also had the same experience where somebody's maybe struggled with their credit and they're really looking for a fresh start, and we give them that. And oh my gosh, they are amazing residents. They treat everything like it's their own. They're honest. They communicate so well. They're so nice. They're patient. So I believe I found a little bit of a trick, and hopefully this will help you. I think communication, you can tell if they are kind of on the high maintenance end or if they're really good at just being good at communication and responsible and easy to work with. So during our application process, we do everything that you do. We background everything, get the references, but we do a little bit more of just questions to get answers. So for instance, if there's something on their credit report that's not even all that negative, we will reach out and we will just say, hey, I see a couple years ago that you bought a car and you've been great on those payments. Are you planning on purchasing a new car, or are you keeping this car? Now, the resident might think, why the heck is the management company asking me that? But by their answer, we can tell if they are high maintenance and rude, or if they just answer and are really easygoing. So you don't want to be too invasive, so be careful with what your questions are. You want your questions to be questions that can go one way, where they get a little snippy, or they can go the other way, which is just super responsive. Because the super responsive is the A+ tenant. They are going to be the ones that don't give you trouble. And so we have like an internal screening. It's not a perfect science, but it sure has helped us in the course of the last 5 years. We have been able to weed out that quote unquote perfect on paper resident, and we have gone more for what our gut feeling is. And hey, I'm very honest with my owners. When we're in the application process and they have responded something really kind of curt and rude to one of our questions, I get on the phone and I talk to the owner and I'm like, look, they're great on paper, but if this was my rental, I would not rent to them. I would wait a little bit and I would wait for the right resident. And of course, if the owner says, no, Jenny, I need to get it rented, move forward with it, I am probably 80% right on the fact that those residents become high maintenance. And more than likely, when I call that owner back 6, 8, 7 months down the line, and they go, Jenny, you were right. Oh my gosh, that resident just expects me to rebuild the property. I'm never, and I will never say I told you so. It just solidifies that we have our systems in place to kind of weed out that high maintenance resident. It says, debating upgrading flooring from the tile to LVP, luxury vinyl plank flooring. That's what everybody calls that kind of flooring, is LVP. Have a ground floor, 1 bedroom that currently has a tile floor in the living room and kitchen. This was originally done because the boiler room, or the hot water tank, is in a closeted section within the condo. The cost of the upgrade would be approximately $3,500. I've never had an issue attracting tenants, so it's not something that needs to be done. It would certainly make the apartment both look nicer and more comfortable, since the tile needs to get cold in the winter and isn't exactly cozy. From an ROI perspective, I might be able to get $100 more a month, or it just might help with retention. My concerns are, 1, is it worth putting something in that isn't going to have a big material payoff, although will make the apartment better? And 2, from a maintenance durability standpoint, tile is pretty indestructible. I'm asking for a headache by putting a nicer LVP on top of it and then having to worry about upkeep. My opinion, if you have good tile don't mess with it, especially in a rental, because the luxury vinyl plank flooring, it's water resistant, but it's not waterproof. I have actually seen many of our rentals where we have laid down, or the owner has laid down the new vinyl plank, and it starts lifting, water gets up underneath it in the kitchen. I am a ceramic tile girl through and through. I know there's trends. I know it's a little cheaper usually to do the plank flooring, because you can get some pretty cheap plank flooring. $3,500 seems like quite a bit, but there are some cheaper versions than ceramic tile. But my recommendation is if it is not hurting you from a rental standpoint, do not mess with it. There's a lot of other things you can do to the unit to add rental value, like new appliances. How about quartz countertop? How about some really nice baseboards to go into the property? Freshly paint. Obviously, that's kind of a no-brainer because you want that to look really good. But to rip up good ceramic tile, to lay down a trendy kind of flooring, I say, no way, Jose. I would not be doing it. And that's just my opinion. Okay, here's another question. Tenant has a great rate on a studio apartment, probably the best in town. However, they have been renting 4 months now and always pay $10 less than the rent amount, despite the rent amount clearly stated in the signed lease. The first couple months, she has gone back to the bank and deposited the missing $10 after being messaged about it, and a lot of back and forth. The second time, we waived a late fee even though she was late. But this month now, she again paid late and $10 short. What should she do? Okay, easy. This is the easiest answer. Do not accept partial payment. The late fee becomes the rent if you have documented it correctly in your lease on whatever day. So our leases, the rent becomes late on the 5th of the month. So on the 5th, there's an automatic 5% late fee that is added to the rent. So if a resident comes into our office or wants to try and pay online, only their rent, they won't be able to. That would be considered partial payment, and we do not accept partial payment. So I think this individual needs to be very firm. She's already been gracious on the first couple of months, which quite honestly, the first 1 or 2 months when a resident is getting used to their lease, getting used to how to pay, I mean, we will waive one time because we want to make sure that we have a good relationship. But after that learning experience, no. The resident needs to pay their rent on time as the contract states. If there's a late fee, they need to pay the late fee with the rent. Period. End of report. Do not accept the late rent. What I think is happening here is a lot of self-managers allow the resident to just deposit the rent into their Venmo account or their Wells Fargo account or whatever it is. I think that's when you run into trouble, because when you are a property manager, you have the ability to have what's called a tenant or resident portal. And we, as a property manager, will put the rent in there, post the rent, and then on the 5th of the month, there's an automatic late fee that is posted to that portal. If that resident tries to pay anything less than what is posted in the portal, it doesn't accept it. So that is one way that we avoid situations like this. And that is why they have to call us, explain what's going on, because we're the only ones that can remove the late fee and then allow the resident to pay just the rent. So it is unfortunate when you are managing your own rentals. There's a couple loopholes that tenants and residents find. I mean, just think about it. I know it's only $10, but if you do it over the course of the 12 months or 2 years, that could be $1,200, $2,400. And all she's doing is just making it kind of miserable. She keeps saying, well, I can't go. Oh, it's a pain in the butt. Oh, my, money order is as much as what the $10 is. Can you just waive it? Well, a contract's a contract. And what I always like to say to the residents that want to gripe about their late fee is, look, you signed this agreement. You knew when rent was due. You need to do your part of the contract because you expect the owner to fulfill their part of the contract. So if the AC stops working, you are going to expect the owner to send a vendor and make sure that your AC is working within 48 hours. So it's the same thing. You need to honor and respect the written document. And yes, you can be gracious on the first or the second month and waive that late fee, but do it once, only once, and make sure you communicate that you are being very gracious on waiving this late fee and explain to that resident it's not going to happen again. It's a one and done situation. You're late again, you are going to be paying a late fee. And then this is another thing to remember. In Nevada, when you're late, when the rent is late, you will want to serve a 7-day pay or quit so that the courts can start the process for the eviction. And you want to make sure that the resident understands that once the 7-day pay or quit is served and you go before the judge, you do not by law have to accept the rent. I mean, a lot of people think, oh, as a resident, I'm going to go to court, I'm going to plead my case, I'm going to bring in my money, and that landlord's going to have to accept that money. No. You're already in breach of lease when you haven't paid rent on time. So if I'm before the judge and my owner does not want to accept that rent because we're tired of that resident being late or the back and forth or whatever it is, they can simply say, Your Honor, we do not want to accept the rent. We would like to continue with the summary judgment so that we can get possession of the property back. So I would say, residents out there, if you are playing the late game, you are in a very scary game. You do not have the upper hand on that. At least in Nevada, you don't. All right, I've got another question, and this one's a good one. I like this one. Who pays for the service call when there's no issue? As the owner, I was charged $185 for a service call on an AC unit that is working perfectly. The tenant thought it should be colder, so they actually put in a ticket. The AC unit is relatively new, and when the vendor went out, found nothing was going on, diagnosed it that it was just really, really hot outside, and where the resident had actually set the thermostat was never really going to get that cold. So before I answer this question, there's two parts to this. First, did you know that there is only going to be a 20-degree difference from what is outside to what is in a home, unless your home is super, super insulated. But rule of thumb is a 20-degree difference. So in Las Vegas, that's really important because if we get in the middle of the summer, in the middle of the day, 110 degrees, it doesn't matter how great the AC is, it is still going to feel a little hot inside. I mean, you can close all the blinds. That helps. You can make sure that you haven't turned the AC up and then trying to get it back down again. There's a couple tricks that would help. But the thing about it is the AC can only cool 20 degrees difference from what the outside is. So we get a lot of calls. We get calls when it's 110, 115 degrees outside, and they're saying, something must be wrong with my AC because I can't get it down to 70 degrees. Well, you're never going to get it down to 70 degrees. So we have to do education with that resident to let them understand that there are going to be a couple times throughout, the summer that you're just going to have a little hotter, maybe bring a fan and help that out a situation. But that is what it is. There's nothing we can do about it. We're not going to reduct the rental and add an additional AC unit so that on 115 degree temperature, you can get it down to your 70 degrees. It's just not going to happen. So education, number one. Number two, let's answer this question. So nothing was wrong with the AC. User error. So resident called in for a work order. Vendor went out. Vendor determined nothing's wrong. Resident should pay the service fee. Simple as that. If the resident said something was wrong and something is not wrong by a professional, certified, licensed vendor, then that service fee is the responsibility of the resident/tenant. So the way we handle it, we explain, obviously there's a documentation from the vendor that says nothing was wrong. They were there on such and such a day. This is how they determined it. We send that over to the resident and we say, okay, this $185 service charge is going to be reflective on your next rent charge. So on the tenant portal, they will read rent, plus it will also read this $185. And I'm a stickler. I am going to make them pay all of it with the next month's rent. I'm not going to just accept the rent and then go back and forth on why they should or should not pay the service charge. If the service charge was sent out there because a resident said something wasn't working and it was clearly working, then the resident needs to pay that service charge. As simple as that in my world. So hopefully I've been able to enlighten you a little bit about these HVACs in Las Vegas or in Southern Nevada. And I've also been able to tell you, do not pay for service charges on something that was totally working on your rental. I hope this has been helpful. I'm going to be doing more of these, but so send them my direction. I'm Jenni McKenna, and I'm the owner broker of McKenna Property Management, and it's always a pleasure to talk property management with you.